Judge Morris, do you want to lay out the facts and wellness for us?
Let me get there, if you don't mind. All of y'all, I'm so impressed with y'all. You can do this all off your top of your head. I stay scripted. Wellness is. I'm a judicial colleague to Justice Sotomayor. Is that not? I mean, that's the best thing. Help me out here. Here we go. This was. Actually, it was a fight over collecting attorney's fees. That's in the lower court. And what happened was the attorney discovered that a bank petition had been filed, and that there was this hidden trust, and that he then admitted that the adversary proceeding was a core proceeding, and at the district court, the sheriff is his name, Sharif, attempted to argue that the bankruptcy court opinion should only be treated as a report and recommendation. On appeal to the Seventh Circuit, the court reversed, finding that the issue of consent could not be waived to the fact it implicated the separation of powers doctrine, and a litigant could not waive a stern objection. Supreme Court. This one, in my opinion on this one, just so you know, if you are a Supreme Court groupie, you want to read Roberts' dissent, because I think Roberts' dissent really talks about how Roberts views not bankruptcy, but his role in jurisprudence and where he needs to be. That's just my opinion. Although I must say,
I really enjoyed Justice Sotomayor's response to his "the world is ending," they're saying, according to the chief, the world will not end in fire and ice, but in a bankruptcy court.
Exactly.
And she might be right on that for other reasons.
And basically what they said was the entitlement to an Article III judge is a personal right and therefore waivable. So I am Justice Sotomayor's judicial colleague, and I do remind Judge Bob Katzman of the Second Circuit and Chief Judge Preska of that on occasion, that I am their colleague, or they're my colleague. And basically,
you're not just one step above law clerks anymore.
No. And I do have...
Which opinion was that?
I don't remember, but
it was painful.
Wasn't that Stern?
I'm trying to remember.
I think that's Stern.
Earlier, yeah.
Anyway, what they rely on is the Commodity Futures Trading Commission versus Shore, and that's in 1986. And basically, it was the Commodity Futures Trading, not a bankruptcy judge, a Commodity Futures Trading Commission was empowered to hear complaints against brokers, and wrote a regulation giving itself the right to hear state law counterclaims as well. And basically, if you agree to it. And so that's where, that was the basis of theirs, of this decision. So there we are. But let me bring you up to date right quick. We got an email yesterday from the Rules Committee sent out to all bankruptcy judges, and I don't know who else, that basically says we want to fast track putting into the Federal Rules of Procedure a consent something within the rules. I didn't get to read it in detail. And so a few of us wrote back and said, what's the time frame on that? And the time frame is we want to put it on fast track, and it would go into effect December the 1st, 2016, so that it would be in the Federal Rules of Procedure consent. Now, we're all on our local rules putting in a consent provision.
So what is that? What do you do in the Southern District?
We're in the process of putting it in. I think it goes effect, I don't know when, quickly. I think I just signed it yesterday. That basically says that, I don't remember what it says, but it is a consent provision within the rules.
So the important thing here on consent is not what the rule is, but that it be clear.
Exactly. Voluntary knowingly. And so, okay, the big question for me on all of this is, I think I get consent if they're in front of me. I almost think it overrules Stern to a certain extent. He was there. I mean, it doesn't really overrule Stern because there are the core and non-core and the other matters. But the idea that Marshall was there with a proof of claim and in the adversary proceeding and actively involved. It just seems to me that there might have been an implied consent there. That's history. We don't have to worry about that. I just wonder about the default, where the person comes in and says, don't touch me, I'm not answering, I'm not doing anything, I'm not consenting, I'm not here, and then do they get to argue it later? That's sort of my take on what the real issue is here.
Craig?
Judge, can't bankruptcy judges police that, right? I mean, the rules now say that when you file an action in bankruptcy court, you're required to say whether it's core or non-core, and if it's non-core, you're required to say whether you consent to the entry of final judgment in the bankruptcy court.
That's right.
The answer needs to agree or disagree and say whether you consent or not.
And they breach it all the time.
Correct, but can't bankruptcy judges then say, I'm sorry, I don't understand whether or not, because this problem, it's a real problem of we can't tell whether someone consented. They participated in litigation, they seemed to have taken advantage of the process, but they never said expressly they consent. And now here we are afterwards, and you ruled against me, and you say, oh, well, I never consented. That's a real problem, but it seems that bankruptcy judges at the front end, by saying, before we proceed here, I've got a question. Do you consent to my entry of final judgment or not? And get an answer to that question.
No, you really want it in writing. So that's why we say you're putting it here, you're putting it in your scheduling order, you're putting it in a pretrial. We try to put it in a lot of different places. And
shouldn't that solve the problem going forward?
I personally think it should. Mine still is a default, you know, where we really want finality, and default you can't believe how many times have you noticed them, are you noticing them again, what are we doing, let's make sure this default is valid.
So Judge Glenn, I don't know how many of you are aware of this, Judge Glenn wrote a very interesting opinion in a case called Metaldyne, where, are you familiar with this one? All right, so here are the facts. The debtor in possession sues a third party on what is clearly a stern claim. I forget it was a fraudulent transfer or some other kind of recovery, that it was clearly a secured claim. Properly serves, files the proof of service, there is no response. A default is entered, and then the question comes up, can the bankruptcy judge enter a default judgment, an enforceable final judgment on that default, or does it have to go on report and recommendation to the district court? And he said, if you look at the rules carefully, and almost none of us follow this rule, I think it's 5005, it says when the judge issues the order, or whatever order it is, the clerk shall enter the order on the docket. Judges don't enter orders.
Correct.
Clerks enter orders. And it also, a rule in the 5000s and a comparable rule in the FRCP says, if there is no response and a default is taken, the clerk shall enter judgment for the plaintiff for the amount stated in the complaint. And it's got to be an amount stated. It can't be an amorphous kind of remedy. So Judge Glenn says, oh, wait a minute. If a clerk can enter a default judgment on the record, on the docket of the case, are you telling me as a bankruptcy judge I can't do that? Of course I can. That is a ministerial act, and it doesn't require report and recommendation to the district court on a default. So I commend that to you. I think it's a very well-reasoned and very well-written decision.
And just as a follow-up, on remand, the Seventh Circuit concluded that Sharif had waived his personal right to an Article III adjudicator by not timely raising it in his opening brief, and they compared it to consent and said that the Supreme Court had made it clear that the Seventh Circuit could now enforce this waiver as it did not have any structural ramification, and affirmed the district court. So that's the end of that case.
The Supreme Court tried to make some distinctions between waiver and forfeiture. What did the Seventh Circuit say on remand? Was it waiver or forfeiture?
Waiver.
And why does it matter?
It said waiver of consent.
Yeah. Does it matter whether it's a waiver or a forfeiture?
At least my impression of that was that the court was distinguishing there between the forfeiture of the right in the bankruptcy court versus sort of the doctrines of appellate waiver. One of the issues in Wellness itself was that this core non-core issue wasn't raised on appeal to the district court or an appeal to the Seventh Circuit, and only sort of arose after Seventh Circuit briefing was complete. So there was a sort of a confusion between the question whether they consented, but sort of forfeited the right to insist on a Article 3 adjudication in the bankruptcy court versus waive the appellate issue by not raising it on the way up. And I think that was the distinction that the court was trying to draw upon.
We still do have certain claims. There are still certain findings of fact and conclusions of law. And of course, we do have the local rule that allows for the district court, if someone appeals something and says, wait a minute, this is a stern issue, they can convert it to findings of fact and conclusions of law on the spot.
Just to sort of underline that a little bit more too, with all due respect to Judge Glenn, right, we have to remember, right, in Wellness, the Supreme Court and Stern, the Supreme Court's dealing with Article 3, and I'm not sure they so much care what the federal rules of bankruptcy procedures say about who can enter orders. So there still may be an issue there that the Supreme Court is worried about that will not be resolved by a reference to the rules. So.
Obviously, a lot to talk about on the jurisprudence of Wellness, but I don't know that that's going to help us a lot in practice, and I don't think the Supreme Court is going to touch this issue for a very, very long time.
And I can tell you that when Stern came down, the Southern District of New York had something like 1,500 motions to withdraw the reference, and that is down to like it was before.
That was foreseeable. That happened after Northern Pipeline too, and people got comfortable again, and the numbers came back down.
They're just normal now.
Yeah. Let's talk about the next term at the Supreme Court. 5 cases next term, or this term that just started this month. 0 grants of certiorari yet on any bankruptcy cases, interestingly. I guess they finally got tired of us. But what might be bubbling up in the future? We talked a little bit about a circuit split on the involuntary fees. You wonder whether that is something of sufficient interest to the court, but then you look at a case like Vigeland and the Bullard against Blue Hills Bank, and you wonder, why were those of such interest to the Supreme Court, even if there were a circuit split? So hard to say. But one issue that seems to be bubbling up and is somewhat controversial in the practice and might actually affect how we do things in cases is the structured dismissal issue. Steve, you want to talk about that a little bit?
Sure. If you haven't had one already, you probably will in your career, and that is the busted deal. And the busted deal is what is the premise for structured dismissal. The Third Circuit case in Jevick was sort of the traditional, we have no recourse to do anything in this Chapter 11 case except sell or return the assets back to the secured creditor. The secured creditor has a lien on everything. After we do that, what are we going to do with the case? If we convert it to Chapter 7, there'll be some poor panel trustee on the Chapter 7 panel that inherits a lot to do with no way to pay himself. On the other hand, you may strand administrative expense claims during this process because there's no money to pay for them. And leave aside the criticism about Chapter 11 as nothing more than a sale of assets these days. What do you do with the case after you've done that sale and you have no ability to effectuate a Chapter 11 plan? And that is what has led to the idea of structured dismissals. In Jevick, that was their situation. They had sold the assets, the cash was encumbered, they had nothing to do. So the parties got together and said, how can we bury this case in the easiest possible way, take care of the administrative expense claims, because that is at least one premise of a Chapter 11. If you're going to use the process, at least pay the post-petition claims. Structured dismissal, to me, it's just a period at the end of the comma, at the end of the sentence. The dismissal is just dismissing the case. It's everything that comes ahead of that that is what people think of as the structured dismissal. And you've got proceeds, you decide where the proceeds are going to go, who's going to get them, and you implement that through a settlement agreement. The interesting thing about Jevic is that they left what may have been considered a fairly significant party out of the settlement, and that was the various drivers with their wage claims. The bankruptcy court got over that. In my mind, it was because he was faced with a mess, and this was the only way that the mess could be taken care of on a fairly efficient manner, pay the administrative expenses, transition the assets that had already been sold out of the estate, and get some semblance of turning something bad into something not so bad. While we had a case that we filed last year, was an oil and gas E&P exploration company. It's called Endeavor International. We filed the case in early November of last year when Brent oil prices were $90 a barrel. We filed the case with a restructuring support agreement and a pre-negotiated Chapter 11 plan. Walked into court and said, "Judge, we've got very good things to say. Our plan been agreed to by all these parties in a complicated debt structure, and we're ready to go." Along came January, February, and March, when now Brent oil prices were below $50, and we went to the bankruptcy judge and said, "Judge, the plan we told you about is no longer feasible, so we are going to sell all the assets of these estates, and it is our idea to do that in a responsible way, pay our administrative expenses, and then dismiss the cases." We were hesitating for the longest time in calling it a structured dismissal. We would call it an orderly dismissal, a structured dismissal. But then Jevic came down, which sort of gave us some credence to talk about a structured dismissal. And what we did in that case, which was similar to Jevic, we sold the assets with respect to principal assets on which the secured creditors had a lien. We did a marketing process. Ultimately, they ended up credit bidding for those assets, and in part of that deal, they agreed to set aside funds as a wind-down budget to pay administrative expense claims and to allow the debtors' estates to wind down and ultimately dissolve the entities. Somewhat like Jevic, in that case, we did not initially provide for anything to be paid to the unsecured creditors. The numbers were pretty plain. The secured creditors had a lien or an adequate protection super priority claim on any of the cash that was available in these estates. So we just did the math and proposed that they would get the assets, they would set aside funds or allow use of existing cash to pay administrative expenses and wind down, and then we would dismiss the cases. We went into court with that proposal. The bankruptcy judge in Delaware, Judge Carey, explained to us very carefully how he is not adverse to a structured dismissal context, that he had done it before. He does not like to. Definitely prefers a Chapter 11 plan, but that he would not do a structured dismissal in the face of any opposition, somewhat unlike the Jevic case where there was substantial opposition. So in our settlement agreement, we renegotiated the deal. We set aside a fund of cash to pay unsecured creditors. And last Friday, the judge entered an order approving our settlement, approved various releases contained within that settlement. Carefully designed releases. They were only releases of debtor causes of action or otherwise were consensual releases by and between the parties to the transaction. And yesterday we closed the credit bid transaction, and the case is on its way to a dismissal. Like I said, the actual dismissal order is just the period at the end of the sentence, because everything that was part of the structured dismissal was done ahead of time. And once we certified to the court that we closed the transaction, set up our wind down fund, and made the distributions to unsecured creditors, then the judge will enter an order of dismissal.
So that's probably the simpler and easier case. The two tougher examples of two much tougher cases are the the Jevick case, which you mentioned, and the ICL Holdings case, which the Third Circuit decided last month, both of which involved priority skipping distributions, which is where the objections came from. You didn't have that in your case. I would ask if we're seeing this outside the Second or the Third Circuit, but most of these large cases like this are being filed in the Second or the Third Circuit, so we're less likely to see them out there. But any experience?
Well, I think what
you're aware
Stephen
of?
just said, though, is when you're in and you're trying to do one of these, there are certain things, certain, not buzzwords, but certain evidentiary type things you're going to need to bring to the court. And that is that you're approving a settlement that deviates from the priority scheme, and it has to be specific and credible. And that's the quote from the case: specific and credible, and should be in rare circumstances. So you come in arguing those and give the evidence of why this is specific and why this is credible and why we need to do it, and we understand this is rare, and you make your argument.
And
So,
one theme on the skipping priorities, a consistent theme is whether the monies that are being distributed are estate property or whether these are monies of others. The ICL case out of the Third Circuit, it was clearer, and they made the distinction that it was the buyer's money that was being distributed to creditors and not estate money. There was a side dispute whether was the buyer paying 10 for the assets and giving 2 to creditors, or was it really that the buyer was paying 12 for the assets and 2
well,
was
in the ICL case, the buyer was the secured lender who had a lien on everything, including the cash. I wonder if you might get a different result if it were truly a third-party outside buyer in that circumstance, whether it's 10 plus 2 or whether it's 12 for the assets.
Maybe it's just wording, but you know, the secured creditor had a lien on all the cash, so I'll take my cash, I'll take it out of this pocket and hand it back over to the estate.
I think ICL certainly does suggest some tips for structuring that if you want to skip priority, it's much better to get the cash out of the estate first and then do whatever you want to do with it. You know, that at least seems to be the roadmap that Judge Ambrose is providing there in that case, that the way you structure it actually does matter for the outcome.
And I'm not sure there's an alternative. I mean, it's a case in which structuring matters, and it relies on formal distinctions, but at some level, I mean, a lot like the discussion about gifting, where saying, well, I'm not actually distributing this money under a plan, as to the estate under a plan in a way that violates absolute priority, because the money I'm distributing is, belongs to the secured creditor, not to the estate. These are formal distinctions. I'm not sure there's an alternative to relying on them.
But I am suggesting that there might be a distinction between belonging to the secured creditor and money belonging to the purchaser, who is not the secured creditor. Right. It used to be many years ago, I recall cases in the small middle market in Los Angeles where the buyer would come in and say, I'm willing to pay $2.5 million for the asset, and I'm going to sign an employment contract with the president, the president and shareholder, for the next 3 years at $200,000 a year. And he's not going to be required to work very hard. And then have the president make the argument, well, that wasn't part of the purchase price.
Yes.
Yeah. Right. And that argument didn't very often prevail. But as I say, if it's a secured creditor who's got a lien on all the assets.
But see, Rich, I think you bring a point that we face. And I was talking about this earlier. One of the reasons why you don't have a lot of decisions on this is exactly what happened to you in Delaware. You make a deal. Everybody's standing in the room holding hands, and I say singing Kumbaya. And it's obvious everybody's made the deal. Everybody's been noticed. Everybody knows about it. And you're the only one up there saying, what?
Yeah.
But
that's the point. In Jevick and ICL, there were objectors. It wasn't everybody.
If you have an objector, that's a different story.
Right.
But by and large, it's everybody. Well, and you make the deal. You go outside and make the deal with the unsecured creditors. I mean, right. That's what happens. And trust me, I think bankruptcy lawyers are some of the best negotiators on anywhere.
We ought
And
to
so
send
they
them all
make
to
it-
Congress.
So, and I think that's one of the reasons why you don't see a lot of opinions on it, because it does happen. You get your attorney's fees because they're approved, then you divvy up everything, and you come to the judge and say, and you're like, okay, now exactly how am I supposed to do this? Well, just sign the order. We're
That's how
all
you
in
do it.
agreement.
And this will not transpose back to Vigelin in Chapter 13, will it?
Well, and the
Listen,
other thing is,
we have-
don't hold me to it. That's mine. Just don't hold me to it the next time.
We have about 10 minutes left. If there are questions, we could take them. The other one topic we were going to discuss was equitable mootness, but I want to give the
Well,
audience...
cert was denied from the Second Circuit on that. The Second Circuit case, BGI,
BGI cert denied?
yeah,
They're not ready for it yet.
yeah, on October the 9th.
Oh, I
The
missed that
issue
one.
was applicable for equitable mootness doctrine in a liquidation case, and it was denied. Cert was
So they're
denied.
not going to take that one. That was the Borders Group, the appeal over the gift cards.
Maybe y'all don't have the three that were denied. The other one was Seaside Engineering and Survey, an 11th Circuit case.
Oh, yeah.
Denied cert. The issue was the bankruptcy court's authority to approve non-consensual, non-debtor releases. And then cert was denied on the 15th of October, and that's a Chapter 12, debtors' aggregate debts, as including unsecured portion of creditor's claim from which the debtor had been discharged in the Chapter 7. So those were the three that were denied in the month of October. Cert denied.
So let me open it up to questions. I saw an occasional hand while we were talking. Did we fully answer all the questions, or is there more to discuss?
On the issue of the Supreme Court, Craig and I were talking, I mean, today is the deadline, too, for filing briefs in the appeal from the First Circuit and the Puerto Rico's attempt to draft its own bankruptcy law.
Oh, okay.
So we will get, I guess, a decision on whether the Supreme Court's going to take that, presumably following briefing.
Deadline for cert briefs.
Yeah, for the response to the petition for cert was due today, so it'll be a little bit longer.
And of course, the Senate, the Puerto Rican Chapter 9 bill, Chapter 9 Uniformity Act of 2015 was introduced
There's
in the
that,
Senate.
and then there was yesterday the administration proposed taking it even a step further and extending it's actually more of a Chapter 11-like concept to the Commonwealth itself as opposed to just its utilities.
Yeah, that's going to be, the Puerto Rico situation continues to develop. The bill in the House to make Chapter 9 available to Puerto Rican municipalities has been introduced. It's been pending for maybe a year now, and it's stalled. It doesn't seem to be moving anywhere. I think there's a bondholder constituency who would like to not see that bill move. I don't think they enjoyed their experience in Detroit too much, so they're transposing that to the island.
Yeah, they at least don't want it to move until they can liquidate their position.
Yeah. Right.
There's also one other bill. It's the Financial Institution Bankruptcy Act of 2015.
Yes, the Senate introduced a companion bill to that. It's H.R. 2947. It would add a subchapter 5 to Chapter 11 of the Bankruptcy Code to deal with financial institutions that are systemically important and have assets of over $50 billion. Right. The Senate, that was introduced in July. The Senate, Senator Cornyn introduced S. 1840, I think this month. It was very recent, which does almost exactly the same thing, except it puts it in Chapter 14 of the Bankruptcy Code, and it has a couple of other important substantive differences that are not bankruptcy law related, but would fall under the jurisdiction of the Finance Committee in the Senate or the Banking Committee in the House, relating to dealing with these entities. Those bills look like they're actually going to move because the House and the Senate are very much aligned on the substance of those.
This has a unique appellate. The Chief Judge of the Supreme Court, Chief Justice, will appoint at least 3 district judges in at least 4 circuits to serve as an appellate panel to hear appeals in a bankruptcy case concerning these financial institutions.
And in
and
the
it'll
House,
have a panel of at least 10 bankruptcy judges.
Yeah, the House bill also
means.
has 10 bankruptcy judges, and I think it is 4 or 6 Court of Appeals judges to hear appeals directly from the bankruptcy courts on on the
Well, it
resolution.
says district here, so yeah.
One reason why these bills might move, unlike prior bills in this area, is because these ones are not tied to the repeal of Title II of Dodd-Frank.
Well, that's one of the main differences in the Senate and the House bill. The Senate bill actually does propose repeal of the orderly liquidation authority in Title II of Dodd-Frank.
Whereas the House does not.
The House does not. And as I said, I think that's a committee jurisdictional issue. And the question is whether, I was in D.C. yesterday actually on a panel talking about this, and the panel immediately before me was Hill staffers, Republican and Democrat, from the Finance and Banking Committees. And you could see that the way that they were interacting with each other was there's going to be no agreement on Dodd-Frank, on even technical amendments to Dodd-Frank. The Democrats will just not stand for even a kiss to Dodd-Frank, and the Republicans, of course, hate it. So the issue on these bills is going to be whether the Senate backs off including the Dodd-Frank repeal or not. In the House, the plan last Congress, was that the bill wouldn't have it, but then the Banking Committee would report out a separate bill that would repeal Title II, and they'd combine them on the floor.
Right. Once they get combined, it becomes political poison is the problem. Once repeal is attached
So
to this.
the scuttlebutt I heard yesterday was that they're going to drop, the Republicans will drop their demand for repealing Title II, and the bill might actually get passed. We'll see. It's a long time. It's a year before the end of this Congress, and we'll see what happens. Dan, you have a question?
Well, yeah. Well, on that, what are the actual implications of having that bankruptcy authority?
Okay. What are the question is, what are the implications more generally of having that?
Well, yeah, in terms of how financial institutions get restructured.
Well, I think the implications are not great. There are only 27, this is the number I heard yesterday, 27 SIFIs in the world, and 9 of them are or 29, and 9 of them are in the U.S. We're not talking about a lot of potential debtors here. And the way they get restructured is through this procedure that's been developed called the single point of entry. I don't know if you don't want to take this. I'll happy to take this offline if others have other questions about other matters, because it's a rather specialized area. But
well, I was just going to add, if we are limited for time, too, I think one reason why these bills, even if they are passed, will be limited. There's no funding mechanism in them for DIP financing for the debtors too.
That's another of the differences.
Yeah, whereas there is one in OLA, so that might lead the regulators to prefer using OLA.
So the idea is that all the big banks in the U.S. are structured under a holding company structure with all of the operating banks, the broker-dealers, all of the trading subsidiaries, everything as subsidiaries. The holding companies have nothing. The bankruptcy petition would be filed, and within 48 hours, the court would approve a transfer of all of the operating subsidiaries to a bridge company, which would be owned by a trust, with a special trustee appointed by the bankruptcy court, after consultation with the regulators as to who that should be. And those operating subsidiaries, to the extent they were insolvent, would be recapitalized by forgiveness of debt that they owe to the parent company. So this debt, the parent goes out and borrows in the market, loans the money down to the subsidiaries to support the subsidiaries, and the plan is that debt is described as loss absorbing capacity, would absorb the losses by the parent forgiving the debt of the subsidiary, converting the debt to equity in effect, and thereby recapitalizing the subsidiaries, making them solvent and able to operate. And then the wind-up of the parent company would go pretty much like the WAMU case did or the IndyMac case did or any of those. Those would go on in the bankruptcy court, but meanwhile, you'd have the subsidiaries under this bridge company that then could be sold or merged or IPO'd or whatever, but it's totally free of the bankruptcy court's jurisdiction, other than it has to provide quarterly reports. Now, that company could probably get financing either if it's a bank through the Fed discount window or in the markets because it's been recapitalized by the forgiveness of all of the intercompany debt. The debtor parent company, I don't know where it's going to get any financing to run the wind down. that's an interesting question. The Senate bill effectively prevents any kind of lending, and I haven't seen the precise words of it, to the bridge company and the subsidiaries, and prevents any access to the discount window at the Fed. The House bill doesn't have any similar provision. Quick question, we got just a few seconds left.
Would the intercompany debt be given in toto or just as much as necessary to capitalize?
You know, hard to say. Probably in toto. The question was, would it be forgiven in toto or just as much as necessary to recapitalize? I think the idea is that it would be fully forgiven. In 48 hours, you're probably not going to be able to deal with a scalpel here.
One sort of hidden problem there is that solves a balance sheet problem. It doesn't solve a liquidity problem at the subsidiary level.
And one of the political problems is that, as Professor Lubben points out, there's a big difference between insolvency and illiquidity. You got a lot of assets. I mean, your house is very illiquid, even though it may be worth lots more than your mortgage, so you're solvent. And banks have the same problem, but anytime anybody talks about addressing that problem in Washington, somebody hurls out the epithet bailout. And therefore, it's just politically unacceptable even to refinance the mortgage on your house, because that's a bailout. So, we thank you all for coming. Natalie, do you want to have any closing words?
Well, were there any other questions in the room? No? Okay. Hi, everyone. Good morning. I'm Natalie Eady. I'm the Commercial Product Director of Bloomberg BNA's bankruptcy offerings. We want to thank you so much for coming out this morning so early and joining us, so we really appreciate it. We want to thank our esteemed panel again and our moderator. We invite you to, if you still have questions, maybe they're still, coming into your mind, our speakers will still be around for a little while. Please meet the speakers, ask them any questions you have, and feel free to mingle and meet any of my colleagues here. Thank you.